5%.
Wonderful. So good afternoon, everybody, and welcome to our webinar entitled, Does the Foreign Sovereign Immunities Act bar prosecution in U.S. courts of commercial enterprises owned by foreign states? I am Michael Todoric, president of the Washington Foreign Law Society. The Washington Foreign Law Society was founded in 1952 to promote knowledge and understanding of international legal matters, comparative legal issues, and foreign law. Today's event features a stellar lineup as moderated by our very own Mark Feldman, our very own board member here at WFLS. If you're connected here, you probably know Mark already, but I'll introduce him anyway. Mark is former acting legal advisor at the U.S. State Department. He's been a practitioner and teacher of foreign relations law for decades, and just to name a few of his professional highlights, he helped to draft the Iran Claims Agreement, the UNESCO Convention on Cultural Property, and of course, the FSIA. And we discussed all these in a podcast with Mark recently, and I'll put the link in the chat box so you can listen in if you wish. Just a few quick housekeeping notes, Mark, before I let you introduce our distinguished panelists today. Please send any questions you may have using the Q&A feature on your screen. And I see we already have some questions coming in, so I expect more and more to come. And we'll get to the questions at the end of the program. As a reminder, the session is being recorded, and we'll post the recording on our YouTube page and on our website after the event is over. And finally, don't forget to follow the Society on Twitter and LinkedIn. We upload not only the recordings, but also all of our updates and other events. So feel free to follow us there. And one final note, please consider becoming members of the Society. There's discounted rates for students, nonprofit professionals, government professionals, and so on. I'll be putting a link in the chat, but please do consider becoming a member. And now, Mark, the floor is yours.
All right, thank you very much, Michael, and thanks always to the Washington Foreign Law Society for hosting such a fabulous program throughout the years, including annually at least one program on the FSIA, paralleling, reflecting the fact that the Supreme Court in recent years has almost always taken at least one case, sometimes more than one case, for its term agenda. Tonight, the case that we're discussing, the prosecution of Hulk Bank by the United States, is really a major case potentially with serious implications for the law, for U.S. national security, particularly the administration of our sanctions program, and for international relations. It's a major issue bilaterally between the United States and Turkey. And I'm quite surprised that it hasn't received all that much attention as we come up to the argument, which is 1 week from tonight in the Supreme Court. It did receive quite a lot of attention back in the Trump era when Erdogan actually prevailed upon Trump to have his attorney general fire the district attorney, U.S. attorney in New York, who was handling the case at the time. But tonight, we're not going to be focusing on the politics, domestic or foreign. We're going to be talking about challenging issues of law involving whether under U.S. and international law it is feasible for national courts to prosecute or entertain criminal prosecutions of a foreign sovereign, or more particularly an instrumentality of a foreign sovereign, and where does the Foreign Sovereign Immunities Act fit into this picture? And I must say, we could not have a better panel to discuss these particular issues. We have perhaps, I'll say without hesitation, I would consider these three the most prominent, reliable commentators on foreign state and foreign official immunity that we have right now. We begin with Professor Shimon Keitner, who comes to us from the University of California, Hastings College of Law in San Francisco, where I gather the weather's been bad lately. And she has a distinguished record of service and publication, as do all of our panelists. More recently, she was a counselor on international law at the State Department. You can tell from the brief bios that you have that all of us have some State Department connection. I have to say mention two particular publications. One was her article just a couple of years ago on prosecuting foreign states, which really hit the mark as far as this whole topic is concerned. Then I also want to salute Professor Keitner for joining me in a brief supporting the government's position that we filed in this case just a few days ago. I never would have got it done without her, and anything that's good in the brief, I want to credit her with, and none of you will be surprised at that. Professor David Stewart comes to us from Georgetown University, and his very brief biographical note is very modest indeed. He says very little about his years-long experience in the State Department, and I had the pleasure of working with Professor Stewart at State and teaching classes. I think, 3 different classes, David, over almost 20 years, I think. We all learned a lot from each other and from the students. And I want to just mention one thing in particular. Well, you can see in the notes that Professor Stewart and Professor Brunk were co-reporters of Restatement 4 material on foreign sovereign immunity. So that's about as good a credential as you could get for this topic. Professor Stewart also was the U.S. Representative to the UN negotiations on the UN Convention on Foreign State Immunity. So he's well placed to share with us the perspective of of states other than our own on this controversial subject. I'm particularly honored and delighted to have Professor Brunk here because I've been reading her work for years and never really had the opportunity to meet or to engage in any projects together. So Professor Brunk comes to us from Vanderbilt School of Law, where she is both a dean and a research director and a prolific author. And if you want to publish anything in the American Journal of International Law, you'll have to go through her, because as I understand it, you are now co-editor-in-chief of, if not, well, certainly one of our most prestigious journals in the field. Having said that, I'm not going to take up your time on the merits, and I'm going to pass the microphone to Professor Keitner. Shuman, please tell us what is this case all about?
Well, thank you so much, Mark, and thanks to everybody for joining us. I think it was David years ago who kind of coined the term immunity community, and so I'm honored and delighted to be a card-carrying member, and it's certainly a club whose agenda kind of never ceases to grow. So in the time available, I'll try to fulfill my mandate of setting the stage. Obviously, as Mark said, we co-authored an amicus brief that flows from an article that I had previously written before this case came across the Supreme Court's docket. So we obviously have a particular view of the substance of the issues, but very much look forward to welcoming and discussing a variety of viewpoints. And one of the reasons that this society is such a great gathering place for these conversations is obviously the Hulkbank case provides the occasion or the opportunity to discuss these issues, but they are issues that have cropped up in a number of other cases. So just to set the stage, the assertion of civil jurisdiction over foreign states and state-owned entities has, of course, long been a matter that has perplexed the courts and decision makers. And Mark and his colleagues in 1976 did everyone a big favor by smoothing the passage of an enormous statute that sought to simplify life in at least some respects by taking state immunity determinations in civil cases out of the hands of the State Department and put them squarely in the hands of judges who thenceforth were to decide whether or not a particular defendant in a civil case could claim jurisdictional immunity, by interpreting and applying that statute. Now, as Mark said, of course, as with many statutes, complexities and unforeseen circumstances have arisen that have required Supreme Court intervention and clarification. And so we've had a steady stream of cases interpreting the FSIA. But only one or two of those cases have posed the question of whether the statute applies to the question at hand at all. And so a notable such case was the Samantar case back in 2010, about which all of us, I think, have also written, and in which I also participated as an amicus. And the question in that case was whether the immunity of individual foreign officials sued in their personal capacities was governed by the FSIA at all, or by some other body of law. And the Supreme Court decided that the latter answer was the correct one. It didn't give us much more to go on in terms of where to discern the applicable rules of what it called the common law of immunity in that area. And so debates have persisted in the lower courts about that. But at a minimum, we did find out with the Samantar case that the FSIA is not completely comprehensive when it comes to questions of jurisdictional immunities. This case, the Halkbank case, which is styled Halkbank versus United States because the US government prevailed in the Second Circuit and the decision below, involves, as Mark alluded to, the enforcement of US sanctions regime, somewhat controversial set of sanctions, but that are very far-reaching and that have, as part of their foundation, criminal enforcement mechanisms against both individuals and entities that run afoul of their provisions. And there have, in fact, been prosecutions of individuals associated with Halkbank for sanctions violations. And what we are dealing with in this case is the proceeding against the entity itself. So the entity has argued that it is entitled to immunity as a foreign state. And the arguments that it has made have evolved somewhat from the trial court to the Supreme Court, as have the United States' arguments. So where we are now, I think, is in a very interesting place with a couple of issues potentially in play in next week's oral argument. A background set of questions involves what international law may have to say on this matter. And I call that a background set of questions because particularly with the court as it is currently composed, it's unclear to me how much direct reference there will be to international law, either in the argument or in an eventual opinion. But certainly there are international law arguments made in the briefs, both by the parties and by amici. And I think the two really important things to focus on in terms of the international law is, number one, is there a distinction, a meaningful distinction, between a foreign state and a foreign state-owned enterprise? Now, there's a subsidiary factual question because it appears from the briefing that this entity, Halkbank, is majority owned by another entity, the Turkish Wealth Fund, which is itself majority owned by the state of Turkey. And so under a case that those of you in the immunity community are aware of, the Dole Foods case, it would appear that Halkbank is too far removed from the state of Turkey itself to even claim what we call instrumentality status. But that point does not seem to be before the court at the moment. We seem to be proceeding as if Halkbank is a state-owned entity. And if that's the case, Halkbank argues that both under international law and under the FSIA, if it applies, an instrumentality is entitled to the same immunity from jurisdiction to which a state itself would be entitled. Now, Mark and I take issue with that argument, both as a matter of international law and practice, and also under the FSIA, where, as we point out, instrumentalities and states themselves are subject to different regimes when it comes, for example, to things like service and punitive damages. But that is one set of issues. So are we talking about foreign states, or are we talking about instrumentalities? And although Halkbank suggested in its reply brief that this argument has somehow been forfeited or waived below, to the extent that it goes to subject matter jurisdiction, I think it absolutely is and remains front and center. The other question about international law is, does international law distinguish between civil and criminal proceedings? Is there a distinction to be made, again, just purely as a matter of international law, when we're looking at state practice? And should it be relevant that we see, or appear to see, at least in reported opinions, fairly few prosecutions or criminal proceedings against state-owned enterprises, and virtually none that we're aware of against foreign states themselves? Now, Mark and I argue because international law has consistently treated state-owned entities as something quite different from foreign states themselves. That's not material to the analysis, but certainly Halkbank differs on that point and makes emphasizes quite strongly the relative absence of criminal prosecutions of either states or state-owned enterprises. I should maybe parenthetically note that another recent cert petition that was denied involved this question with relation to a subpoena, a grand jury subpoena, rather than a criminal prosecution, which was also, of course, an exercise of criminal jurisdiction, just another kind of criminal jurisdiction. And that case did attract some more attention because the subpoena at issue was issued by a grand jury that was a spinoff of the Mueller investigation. It turns out that the subpoena was directed at an Egyptian state-owned bank, and the DC Circuit found that jurisdiction was appropriate in that case. So then let's move very quickly to the statutory questions. The jurisdiction asserted by the United States in this sanctions enforcement arises under Title 18 of the U.S. Code, which provides in Section 3821 that there is jurisdiction in the federal district courts over all offenses against U.S. law. Halkbank, in its merits brief, makes the quite interesting and novel argument that that jurisdictional grant itself excludes foreign sovereigns from its purview, and again then defines a state-owned bank as being a foreign sovereign for immunity purposes. And again, because my job is both to set the stage and to give you a sense of what Mark and I have argued, we argue both that the jurisdictional grant does not have sort of built-in ex-ante carve-outs, and that the suggestion that it does is based on a fundamental misreading of the Schooner Exchange case that everyone loves to quote. And moreover, that even if there were some sort of carve-out, that would not extend to state-owned enterprises that have traditionally been treated very differently from foreign states themselves. So we have a Title 18 question in the mix. And then finally, and in my segue to David Stewart, we have the famous FSIA that I understand is a favorite of this society to discuss, and the, in retrospect, perhaps somewhat unfortunate phrasing of Section 1604 of that statute, which provides, as I'm sure many of you know, that a foreign state shall be immune from the jurisdiction of the courts of the United States and of the states except as provided in the statute. Now, I think read in context and in light of the legislative history and intent, of course, about which there's no one better qualified than Mark to educate us, the goal in codifying this in Title 28 was very much to create a jurisdictional framework for exercises of civil jurisdiction. But again, on its face, the text of that provision, read acontextually, certainly does seem to strip the federal courts of all jurisdiction over foreign states. The FSIA, in turn, defines foreign states to include directly owned instrumentalities, at least for certain purposes. And so again, in our view, an improper construction of the statute would lead you to think that even if an exception to immunity applies, such as that for commercial activities with a U.S. nexus, that would only give you civil jurisdiction under Section 1330 and not criminal jurisdiction under 18 U.S.C. 3821. This is precisely what we are debating in this forum and what the justices will have to grapple with next week.
That's a terrific summary. I didn't think you could do it in 10 minutes, but you did. That's wonderful. So now I know that we have some wide range of views on those issues and others that are yet to be raised. So let's turn to Professor Stewart. You have the mic, David.
Thank you, Mark, and thanks, Shemin, for that overview. Let me just give you a series of responses to that series of propositions in order to maybe provoke some debate. My view of this case is simply that it cannot be resolved on the basis of traditional rules of statutory interpretation. The Foreign Sovereign Immunities Act doesn't address the question. I think you've conceded that point explicitly. It doesn't address the question. Your argument is really good. But it says in 1604, as you acknowledged, that the foreign states are immune from the jurisdiction of the courts of the United States and the states, except as provided in Section 1605 to 1607. And none of those exceptions apply to criminal prosecutions. It doesn't say one way or the other. So my starting point is that the Second Circuit's decision, while understandable, is not sustainable. What they've said is there is no immunity from criminal prosecution, but if there is, this case falls within the commercial activity exception. I don't find that a very firm, sensible, rational point of view. It's almost internally inconsistent. But in any event, I don't think that the court can arrive at the conclusion that you want it to simply on the basis of rules of statutory interpretation. The statute just doesn't address it, and there's no indication in the legislative history of congressional intent to subject foreign state-owned entities or foreign states or their agents, other agencies or instrumentalities to criminal prosecution. So in effect, the decision would be a substantive lawmaking issue. And I take the general perspective, which I know you don't agree with in your brief, that it's not the function of our courts to decide this kind of substantive legal question, particularly when we have sitting in front of us the creation of Mark Feldman and his colleagues back when, 1976, the Foreign Sovereign Immunities Act, the point of which was precisely to take this question out of the executive branch and put it into the courts, but subject to codified standards that the political branches enunciated. In other words, the statute didn't say the courts can make up the laws they want, didn't say that the courts can look to customary international law. It said, here are the criteria that you will apply. So I find the Second Circuit's decision unsustainable. And I also think the government's argument here, which is essentially that the prosecutors can do what they want, even more unsatisfactory. It simply untethers the prosecutorial discretion from any basis in the statute or anything else. I mean, if you look at their brief, and there's some language there that is extremely troubling. So we're at a conundrum here. There clearly does need to be a clarification of the law, but I don't think you can arrive at it by means of statutory interpretation. And the government's proposition doesn't give any basis at all for articulating coherent or practical rules. It may be sensible to have a rule that says the Foreign Sovereign Immunities Act was overly broad when it incorporated foreign state-owned entities, such as private corporations, within the embrace of sovereign immunity. I think that's a rational point of view. Whether that view would reflect contemporary practice among states is something to be examined. I think that there are some states that do give immunity protections to what we call broadly agencies and instrumentalities that would include privately incorporated entities if they're owned or operated by the government. I think there are other states that don't. So there's an issue there that needs to be resolved. Personally, I wouldn't think it would violate international law if the United States had a rule that says we're not going to give immunity to state-owned corporations because we think that's become more common. They're more commercial than they used to, more obvious, and we're going to restrict our immunity. That's a rational point of view, but that's a political decision, it seems to me. In light of the FSIA, that's a decision for the political branches based on their understanding of our obligations under international law to make that decision and then to apply it for the courts. It's not something for the courts to do. As it exists, the statute equates them. And so I don't think your argument can get where you want it to go, given the fact that the statute explicitly equates state-owned entities of the kind at issue in this case to the state itself. There's no basis in the statute for making that distinction. And I think the court would be ill-advised and actually doing a job that it shouldn't do if it simply said, well, the statute may say that, but that's not what we think it really means. The last point is that the consequences of this decision are potentially enormous. If the judicial branch assumes to its own power the authority to articulate and to subject to articulate different rules and to subject private-owned entities to criminal prosecution, it's not at all clear to me that the U.S. government's brief has given any sense of what the implications of such a decision might be for U.S. foreign policy, for reciprocity in other countries. Yeah, the United States government doesn't do things like those that are at issue in this case. That is, we don't operate through private state-owned entities. But we certainly do a lot of commercial activities abroad. And in many countries where they produce legal controversies and challenges. In other words, I think the possibility for reciprocal action is quite serious. You find no consideration, at least I couldn't, in the government's brief that any of those possible consequences have been taken into account. To the contrary, as I read the brief, the government's position is the prosecutorial decision is all that matters. And if the prosecutors have decided to go ahead with the prosecution, then all the other concerns stand aside, and even at one point cannot be constrained by a judicially created rule. I think that's an unsupportable proposition. It ignores the basis of the Foreign Sovereign Immunities Act, which is, of course, an appreciation of foreign law, of international law, foreign policy consequences. We're going to have a long discussion, and I'm sure we will at some point, about whether contemporary international law does, in fact, contemplate prosecution of states or governments or state-owned entities, agencies, and instrumentalities. That's a legitimate question to have. But as I read the government's brief, it gives you no basis for making that decision. That's another reason why I think the Supreme Court should not decide this case. It doesn't have a reliable basis outside of the statute. And certainly, I don't think the statute gives it a reliable basis in terms of normal rules of statutory interpretation. So I think the answer here is this is an enormously consequential legal issue. I agree with you that the courts can't just simply make up the rule. But I think in the face of the Foreign Sovereign Immunities Act, and I'd be interested in Mark's reaction here, the United States has adopted a very clear approach to these issues, and that is the joint decision of the political branches to say, all right, we're going to put these cases in the courts, but subject to clearly stated or more or less clearly stated criteria. And for either the court to say, this is now a judicial matter, we'll make up the laws, or for the executive branch to say, as it seems to have done in my reading, international law doesn't matter, foreign policy doesn't matter, it's the prosecutorial decision that matters. Neither of those propositions is right. So I think the court should decline to respond. This should remand the case. I'm not sure what happens after that. My vote would be there should be a proposed amendment to the Foreign Sovereign Immunities Act. How is that for getting some of the rats stirred up?
All right, Professor Stewart, you're good at that. We've discussed these issues together when we were in the State Department together. Let me, if I may exercise the prerogative of the chair for the moment to make some comments on the questions that you have just raised. And I have Professor Brooks' blessing to do that. I know she's got some other very profound comments to make, which were also submitted to the court in an amicus brief, and we'll get to that shortly. First, I think, David, your assessment of the court, I won't comment on your assessment of the court, but I think you misconstrue our position, or maybe you misunderstand it. It is not the brief that Shemin and I wrote does not endorse the Second Circuit's approach. The Second Circuit, as I read their opinion, said, we don't know whether the FSIA applies to this case or not. It did not say that there is no immunity. It said, as I read the opinion, that the prosecution can go forward because if the FSIA applies, there isn't a commercial exception that provides immunity. The other side is saying that the FSIA, and it's not their primary argument. Their primary argument, although it's evolved over time, was well stated by Professor Keitner, goes back, it's an ingenious but somewhat tenuous, I think, argument based on the intent of the drafters in 1789 and an equation of the bank, which is a commercial state-owned bank, but very much engaged in a wide range of ordinary commercial transactions. And the brief equates those two. They say that the bank is Turkey for all purposes under international law. And secondarily, the FSIA supports that position expressly. Now, I can tell you, and we say to the court, we represent to the court, that nothing was further from the minds of the drafters, particularly those in the Justice Department at the time. I would submit that it's quite clear to everybody concerned, I'd be surprised if the courts saw otherwise, that this statute, the FSIA, is directed entirely exclusively to civil cases, and for reasons that we spelled out. The only textual basis for suggesting that it applies at all to the criminal field is the breadth of 1604. That, if you read that in context as part of a highly complex, thoroughly integrated set of propositions, what you're doing, what the bank is doing in this case is saying, we're going to apply FSIA for its framework, but not apply it for the rest of the operating provisions that give jurisdiction to the courts. It makes no sense. And we have cited the Cacerer case, where the issue was not before the court, but the court formulates 1604 the way the drafters intended to write it as a one piece of a three-part puzzle that applies only to civil jurisdiction. I think you would have to concede, you'll tell me, you don't have to concede, not every president concedes these, or former president concedes these days, that if the statute is limited to civil cases and has no application to criminal cases, the issue before the court is whether the prosecution can go forward. And can they say the prosecution can't go forward because we don't know what the answer is to the law, having decided that the FSI does not apply? I think they have to make a decision. And it's a difficult, the consequence, I agree with you, it's very consequential. And one of the questions, of course, is what law, what rules do you apply? But we had this issue before with respect to foreign officials. We worked together in the office at the time I initiated the modern practice of granting official immunity, immunity to foreign officials for their official acts. And that was approved by the Supreme Court in Samantar. I think we all the generations at the State Department understood long before the courts agreed that this FSIA did not apply And there is, maybe you could say there's a policy inconsistency and an institutional inconsistency, allowing the courts to decide in contract and tort cases against states, but not against individuals and not against the U.S. government. I can tell you that I don't think we would have got this bill out of the bureaucracy if we had thought we were constraining the Justice Department or the SEC or anybody else. But you raise a fundamental question that I know Professor Brunk wants to address. Absent the FSIA, what is the applicable law? So let me unless Shemin, you have something you want to say now, you'll have plenty of opportunity later.
No, I'm eager to hear from Ingrid.
Please go ahead, Professor Brunk. You're muted.
Thanks. No, I was muted, but I wasn't actually talking while I was muted. I was looking for how to unmute. So thank you all for having me. I'm thrilled to be here. I'm not going to talk for that long, even though I want to run down the clock because someone has already asked a great question that I cannot answer. And that is like how to pronounce the name of the country, Turkey. So that's a terrific question. I can't answer it. I hope someone else on the panel can. But what I want to talk about quickly are two issues that have already been raised. One of which I wrote an amicus brief on, the other of which interests me. So the first of which is if the Foreign Sovereign Immunities Act doesn't apply, what law does apply and who gets to make the decision? And then the second issue goes to customary international law. How is it applicable here? How do we understand what it requires or doesn't require? The Second Circuit at the very end of its opinion said, well, gosh, no matter what we've already said, anyway, at common law, sovereign immunity determinations were the prerogative of the executive branch. Thus, the decision to bring criminal charges would have manifested the executive branch's view that no sovereign immunity existed. So that one sentence kind of throwaway line reflects a really broad and important debate, one that's manifested itself in a variety of post-Samantar opinions dealing with foreign official immunity. And that is this: does the executive branch control immunity determinations when the statute does not? I argue in an amicus brief that the executive branch does not control immunity determinations, but federal common law developed by federal courts is the proper law to apply. The Samantar case itself said common law of foreign sovereign immunity governs in cases against foreign entities in which the Foreign Sovereign Immunity Act does not apply. Common law is a form of lawmaking that we associate with the judicial branch, not with the executive branch. To be clear, as David Stewart has said, courts have to follow statutes. They should develop common law in ways that are consistent with customary international law. And on many discrete issues, they should and do follow the executive branch. So the judicial lawmaking function here is quite narrow. Nonetheless, it is the judicial branch that gets to decide the principles of immunity that apply in particular cases and apply them. The executive branch argues that it has the authority, not just in criminal cases, but also in civil cases, to decide who wins and who loses. So that would mean, for example, in a blog post I wrote a long time ago for Lawfare, right, that President Donald Trump would get to decide whether Vladimir Putin was a head of state entitled to foreign sovereign immunity, to head of state immunity. I think this is the wrong approach. As I've already said, I think it's the power of the judicial branch. And I'll give you just a couple of reasons why. There's a long history, of course, in the United States, going back to Federalist Papers reflected in cases like Youngstown and Medellin, that the president isn't the lawmaker. It's Congress that makes law, and it's the courts that apply that law in specific cases. And the idea that the executive branch comes in and picks winners and losers, you get immunity, the case is dismissed and you don't, is deeply antithetical to basic separation of powers principles. common law immunity, federal common law applies to a variety of foreign relations related issues, perhaps most importantly to the active state doctrine. There's a well-established body of federal common law governing the substantive issue of the applicability of the active state doctrine. It's a narrow doctrine, but it's very well established. And it's very closely related to foreign sovereign immunity. Both the active state doctrine and immunity go to this basic question of judicial power over foreign sovereigns' property and conduct by foreign sovereigns. In the active state doctrine, this context, the Supreme Court has explicitly rejected the claim that the executive branch should control the application of the active state doctrine. So it would be very weird to have the executive branch control one half of this set of doctrines, foreign sovereign immunity, but not control the active state doctrine. I've seen no theoretical or practical reason to distinguish between these two. Federal common law also applies to a number of related issues. For example, the question of whether agencies and instrumentalities are substantively liable for the conduct of foreign states and vice versa is governed by federal common law in a decision called the Bangkok case. And federal courts make federal common law that applies to foreign sovereigns and agencies and instrumentalities. And again, it's a very constrained sort of judicial lawmaking power, but it chugs along quite uneventfully, and courts seem to be doing a fairly good job there. Forum nonconvenience and a variety of other, for all those students who might be here, all those procedural doctrines too, are examples of places where federal courts make common law. And I think this kind of decision fits comfortably the decision to give or not give foreign sovereign immunity when the Foreign Sovereign Immunities Act does not apply, fits comfortably within these precedents. There are some cases from the 1930s and 40s. I just won't geek out here. They're called Ex parte Hoffman and Ray Peru, and the four of us could really go deep here, I think, on these cases. They say in dicta that the executive branch controls immunity determinations. Those are cases that the executive branch relies on heavily. I'd be happy to talk about them. They're both maritime cases and both present facts that are quite distinct. One of them, Ex parte Peru, explicitly, for example, involves the claim settlement power, which is not a power that is at issue in this case. Beyond that, though, one of the really interesting things about executive control of immunity determinations is, unlike a lot of things, we actually kind of know whether it's going to work well, right? Because we already did this, right, between the 1940s and the 1970s, and the failure of the executive suggestion system was part of the impetus for the Foreign Sovereign Immunities Act itself. And it's an honor to be on a webinar with one of the drafters of the Foreign Sovereign Immunities Act. The executive suggestion system didn't work well. Foreign states pressured the executive branch. The executive branch made inconsistent decisions rewarding its friends and so on. It just wasn't a system that worked very well. I think the experience with judicial application of related doctrines shows that the judicial control over immunity would work much better. I want to say just one response to what David Stewart said, and this is consistent with something that Mark said. David said this is just, we shouldn't have courts or the executive branch doing this. That's a terrible idea, and I don't really disagree with that. I think it would be a lot better if Congress just made some decisions here, and I'm not sure anyone. I think this might be a place where all of us agree. But where I don't agree, David, is what happens. Congress hasn't spoken. I don't think the Foreign Sovereign Immunities Act applies here. I don't think this was what Congress intended. And you said that, oh, the courts just shouldn't decide the issue. I'm not aware of any abstention doctrine that applies here. And either the prosecution's going to go forward or it's not. Right, they're either immune or they're not. I mean, it seems like a decision. I'm just not sure on the practical what your decision actually looks like. What would the Second Circuit actually say? But I do fully agree that the preference here would be to have a statute that addressed this. Congress very often amends the Foreign Sovereign Immunities Act, even when it's not getting a lot of other work done. So all hope is not lost in this area. And David, maybe you could draft up some statutory language, and Mark, maybe you can get it enacted. I just want to say a couple things about customary international law. I think Shemin did just a great job kind of teeing this up, and to make something explicit that she said that I think deserves highlighting. A lot of the problem here is what to do when we just don't have much data. Right? We don't have a lot of invocations of immunity in criminal cases at all involving foreign states. We don't have a lot. So we don't have a lot of we don't really any criminal prosecutions of state-owned enterprises. Maybe we have a few, but when you're sort of looking in the world for custom and you want to have many, many examples that show, consistent state practice, we're just nowhere near there. And so the question is, what do we do? What are the background principles that come into play when we don't have a lot of evidence on this specific issue? Shemin and Mark have said, and I think this isn't incorrect, they've said there are real distinctions between states and state-owned enterprises. So even if you have state immunity from criminal prosecution, maybe that doesn't apply to state-owned enterprises. I would just say I think the differences that they point to aren't actually that significant. Like just because you serve a state-owned enterprise differently than a state doesn't really tell me that one of them is entitled to immunity and one of them isn't. I did not write an amicus on this topic, and I don't have a very well-formed opinion, but I just want to make sure the kind of other side is out there for our audience. And most countries just don't criminally prosecute corporations, and there just really aren't any examples of foreign nations being criminally prosecuted. And I tend to think foreign nations are absolutely immune from criminal prosecution, even though there are exactly 0 cases. So holding, because it simply applies from the basic principles of foreign sovereign immunity generally. So I see the question, agencies and instrumentalities are protected, are accorded immunity. The UK immunity statute, the Convention on Foreign Sovereign Immunities, which David was instrumental in drafting, they do protect agencies and instrumentalities when they're exercising sovereign authority. But that's different than saying they never get immunity. They do actually get immunity in many systems for a variety of conduct, which I think just makes the question more difficult. So I'll end my remarks there. Thank you for the invitation to be on this wonderful panel.
Well, thank you very much for that weighty contribution. And I'd like to take another tour, give everybody a chance to comment on what the others have said. But in the process, I'd like to work in a couple of questions that have been presented. There's one person who put a question in the chat, which suggests that, ask the question, why are we interested in the intent of the drafters when the statute is clear? And I'm just not sure what the statute says according to that person, because if, to my mind, the statute is pretty clear that it doesn't apply at all to criminal prosecutions. But there's a legitimate debate about that. It is then there's a question which I want to respond immediately to Professor Brunk's last comment. There certainly is a question. Professor Stewart says, and the bank says in this case, that the statute equates instrumentalities with the foreign state, that is to say, the government of the foreign state, the sovereign itself. And I don't think that's correct. I think there's a textual argument if you look at 1604, but the difference is that the statute, in my mind, clearly creates a hierarchy by the way it defines agencies and instrumentalities and treats them differently, not just for questions of service, although those are very important to litigants. But on the basic issue of execution, when it comes to it, one of the innovations in the FSIA as against international law, and you can read this in the legislative testimony of the government, was we understood at the time that we were breaking new ground in affording execution of judgment against foreign states as defined in the statute. So we knew that would not be well received in the international community because at that time, most countries observed a kind of an absolute principle of no execution, even though if they applied the restrictive theory. So the provisions for execution are very, very narrow, almost non-existent, some people would argue, in the case of a foreign sovereign, foreign government, central banks, just to give an example, where there's a little confusion as to status, but when it comes to agencies and instrumentalities, including the category that we're talking about here, corporations that are 50% owned, and those, provided that they're an organ of the state, you can execute against any property of that, not just commercial property, any property. And whereas against a foreign state, you can only execute against an asset brought into the United States for the purpose, let's say it's a commercial, if your complaint is commercial, for the purpose of that activity for which you have received a judgment. And another very important difference is the idea that you have no punitive damages against a foreign sovereign, foreign state, but itself in the narrow sense. But you can have punitive damages against agencies and instrumentalities. So we argue in our brief, and I think it's a fair characterization. It's best I can come up with as to what we really intended in the statute. Functionally, we are creating two different categories. The definition of foreign state, for reasons I explained in the brief, includes both sovereign and non-sovereign entities. We don't have time to go into all of the diplomatic history. Some of it is in the brief if you want to take the trouble of reading it. But the agencies and instrumentalities are mostly non-sovereign entities. Now, it is true, as Professor Bung suggests, that there is a lot of practice out there in the international community that says you can execute, that there may be immunity against that an entity that is not the government, that is a corporation, may have immunity if it is exercising sovereign functions. That's a pretty narrow test, and maybe it's the right test. Maybe if we had legislation, even in the criminal context, it would say something like that. Maybe Professor Stewart is right. We should redefine the FSIA in this way. Even the State Department at one time or another has said we would like to consider amending the statute. But I don't think we should amend the civil statute in order to fix the criminal rules. We need something that deals directly with that. Having said that, Shimen, please.
Well, thanks for all of those rich contributions, everyone. And in light of the time, I guess I'll just offer one or two comments that are maybe also responsive to the questions in the Q&A. So I agree. The plain reading of the text, to a certain extent, depends on who's reading. I think the context, maybe, if we're not going to go back so much as far as intent or legislative history, the question would be in the context of the FSIA, which the court has repeatedly invoked when it interprets the FSIA, can we read this language about immune from the jurisdiction within the confines of Title 28? There's an interesting back and forth. There is a section of the bankruptcy code that exposes foreign states to bankruptcy jurisdiction, and I tend to read that one way. The Hulk Bank actually includes that reference in its brief and reads it a different way. So there's some interesting context questions that may not necessarily be drafters' intent questions. On the question of just, what should the court do and what will the court do? I think Ingrid's point is well taken. So David, now or in your next blog post, is it that we dismiss with, let's say that cert was improvidently granted and we just leave the Second Circuit decision in place for now? If we remand for reconsideration, it would have to be presumably consistent with some sort of principles articulated in an opinion of the Supreme Court, in which case, as Ingrid knows, I very much agree with many of her cautions and those that you joined about a categorical executive deference position, but I'm not even sure we would need to get there. I also agree that the Second Circuit sort of, the statute doesn't apply, but if it did, if this is commercial activity, is not conceptually coherent. But something that would be conceptually coherent would be to say, this is a state-owned entity, not a state. The FSIA's definition of foreign state, number one, does not apply in the criminal context. Number two, does not make an instrumentality a sovereign. And this is commercial activity. Therefore, we don't need to reach the what ifs about, what would we do if the US government sought to prosecute a foreign state or a foreign instrumentality or a foreign official, for that matter, for official conduct or sovereign conduct. We can reach that question later and let this particular case proceed. But I'll be curious as to your thoughts.
Professor Stewart.
Oh, there are 14 things I want to say, but I want to hear from the audience more questions. Just in response to Shemin, I don't see a basis for the court to do what you've just suggested. The answer to your question about what would happen on remand is that I hope the parties would say to the court at the whatever remand level is appropriate, that the statute doesn't resolve the question, and therefore we should look to international legal practice and rules as incorporated as matters of federal common law, and have a considered and thoughtful investigation of what the evolving rules are. Mark's quite right. The rules are evolving. The statute is a little bit creaky these days. There's no question that things have changed. Today, prosecutors go after corporations when they didn't used to. I mean, that's a significant change in criminal prosecution practice. Does it make sense in the international area? What are the evolving rules of state immunity with regard to criminal activity, both by the state or its entities and so on? Those are questions that should be briefed. I'm not saying that the court couldn't decide them, but I am saying that before the court as it now stands, and I think before the Second Circuit, these issues weren't discussed. So you have the proposition, if you want the Supreme Court to make the final decision here, that they have no real record on which to make a decision. They would simply be making it up. And while, yeah, I guess a court can make it up, wasn't the whole purpose of the Foreign Sovereign Immunities to say, look, don't make it up, and the executive branch doesn't get to decide it, which is essentially what the government's brief in this case says. Don't bother us, we get to decide it, you're bound by our prosecutor. Neither of those is possible. I think you have to have a rational process. If the statute doesn't resolve it, that you have an argument for the lower court saying, here are the rules. These are the relevant rules. Mark said there's developments in international law about the extent of sovereign immunity and of treatment of agencies, instrumentalities, state-owned entities. That's a substantial change in the law. I disagree with Professor Brunk that this is simply a question of the courts making the law. I think this is a very substantive issue, precisely because it has real implications for foreign policy for the United States. I think it has to be done in consultation with the political branches on a thoughtful basis. The government's brief doesn't really tell you anything about international law and international practice. As I read it, they said essentially saying it doesn't matter. I think that's unacceptable. So if I were a clerk on the court, I would probably tell the judge, I don't see how we decide this. We don't have anything before us to give us a rule. But it's okay because Professor Keitner says we can make it up. I know that's not what you're saying. I'm just trying to provoke you. Anyway, interesting issue.
It is that. Professor Brook, you have another shot. We have an allowance from our host, Michael Zidori, to go on for another few minutes.
David, I'm so sorry to say this, but I actually don't think we're disagreeing about really anything. Like, if you read the amicus brief that I wrote, it says at the end, this should be remanded for further briefing as to the content of customary international law, the views of the executive branch as to the content of customary international law. And I think that courts should then make a reasoned and narrow decision. I don't think that courts should make anything up. I began by pointing out, and I think courts have a really limited area in which they can, in which their decision making operates here. And I think you and I obviously agree, as I've said many times, that it would be preferable for Congress to answer this. And the only other thing I wanted to say was about state-owned enterprises and states. Yes, Mark, I think I agree with all of your characterizations, as well as in terms of the ways that state-owned enterprises are treated differently from states. But I mean, the basic point remains is that state-owned enterprises often receive immunity. And we're left here with a question of a situation in which there's not much state practice. What should the background or what should the default be? Maybe the default should be immunity unless Congress speaks otherwise. So I'll leave it there.
Well, if I may conclude then, and Michael, you'll tell me when time is up, okay? Because on this one point, I want to come to the defense of the executive branch. Not that they're always right, far from that. Not when we were in it, and not today. But the entire structure of international sanctions would have a huge hole in it if you had to wait for Congress, this Congress in this day and age, to come to an agreement on what the regime is. Unfortunately, congressional action, I came to a conclusion long ago that it was impossible to amend the Foreign Sovereign Immunities Act. I spent months trying to do that in 1988 to give a little more leeway for execution, for example. We got a little bit done, very difficult. And I would say that I would give priority. Let me say, from the point of view of try to look at it from a more distant point of view, from the moon, I think you could make an argument that there is a difference between the complexities when you have a private party in the action with rights, and that those rights should have a remedy. So you have a huge public interest in neutrality, that is to say, in a due process and in judgment free from the thumb of executive authority. But when it comes to prosecution, the executive has to take into account the reciprocal. The Foreign Sovereign Immunities Act, when it comes to contracts and torts, is fundamental, and it's very clear both in the legislative history and in all the commentaries then and since, that the U.S. government has twin interests. It's in number one, in affording a forum to private citizens who are doing business with foreign entities, whatever, even sovereign entities. And two, the reciprocal interest of the United States government in not being sued everywhere in the world at the whim of the local authorities of the world. And that's why the State Department attaches so much importance to saying that the minutiae of the statute represent international law. I think they overstate it, but I understand why they're doing that. When the executive is deciding whether to prosecute, they are buying a problem. And that problem is not solved, by the way, even in our bilateral relationship with Turkey. And I don't know what shoes are left to drop in that arena. But would you have Samantar be decided differently? The executive insists right now, the issue that is open, the executive wants its position to be controlling. The courts have not decided on that. I know where Professor Brunk stands on that, but I'm of mixed minds of it. The status of an individual is a little different from, in other words, I would prioritize the public interest in having individuals or corporations who do commercial dealings with states have a remedy against the foreign state or its instrumentality. Having a remedy against an individual raises the stakes, I think, in terms of international order. Governments can't function to the extent that they're individuals that are subject to prosecution, which will take us, to a whole other area of war crimes and so on. It is a complex area. I cannot imagine Congress coming to grips with this responsibly, if I may say that, in the present environment. So I hope the court will do something along the lines that Professor Stewart was talking about and articulate some guidance for the lower courts.
Well, Mark, allow me to interject here to say that we have plenty of material for further and future FSIA panels. So hopefully we'll be able to organize more. And to thank all of the panelists for an excellent program, and of course, all of the attendees and participants who followed through. You'll be able to see the recording very soon. We'll be posting it online and sending it to everybody, to all those who registered. With that being said, thank you all again. And I guess we can close it here, Mark.
Thank you very much.
And thank you, Mark, for moderating.
Thanks, everybody.
Good night.
Have a good night.